Welcome to this live question and answer session with the President of the European Court of Human Rights, Matthias Guyomar, and the Registrar of the Court, Marilena Tsirli. My name is Rachel Kondak, and I will be moderating this session, which will last 45 minutes. We've been receiving your questions during the last week, and it's still possible to send in more questions using the link on the form. Questions are coming in English and French, and I will ask the questions in both languages. So let's begin. President Matthias Guyomar. First, a general question, and the first question, it relates to the role of the European Court of Human Rights in a changing world. Is the court still relevant today?
Many thanks for this question. And first of all, I want just to say good morning to all. Since its creation in 1949, the court has changed the daily life of people. Through the right of individual petition and thanks to its mandatory judgment, the European Court of Human Rights plays an impactful role. It is the judicial body of the Council of Europe, political project built in 1949 to restore all over Europe, after the Second World War, peace and justice, democracy, the rule of law, and human rights. But the world is changing, and we are faced with troubled times. And the values that underpin the convention system, and even the rule of law, are called into question. It's important to keep it in mind. But let me say that the court stands, and within the framework of shared responsibility with all the national authorities of the 46 member states of the Council of Europe, will stand. Through its judgment, the court both provide an effective protection to individual rights and define some standards at the European level for the definition of the European public order as a constitutional court for human rights at the European scale.
President, you mentioned individual rights, and we've received a question related to a criticism that the court just protects those who break the law and not those who abide by the law. What do you say to that?
I often hear something like human rights are not for wrong people. This is fully a nonsense, and I want to reverse that narrative. Since its creation, the court has decided more than 1,100,000 cases for everyone. The court is a court for all people. Before the court, there are no foreigners, detainees, criminals, victims of domestic violence. There are only human beings. And human rights are universal. And the role of the court is to secure these universal rights for all human people.
Thank you. Now over to you, Registrar, another general question that we've received. It's related to gender equality, as International Women's Day is approaching on the 8th of March. Why has it taken so long to have a woman registrar? And more broadly, would you say there is gender equality in the court?
Yes, thank you, and good morning from me too. Well, this is not unique to the court. I think it has taken many national and international jurisdictions a long time before they see women reach the most senior administrative or judicial positions. So in that sense, yes, my election reflects the evolution of mentalities that took place in the recent year, the fact that stereotypes break down. So you're right, the court was established in 1959 and I was elected the first female registrar in 2020. That's a long time. But on the other hand, the registry staff is composed of women predominantly. We have 72% of our staff who are women. As for our judges, we have currently 16 judges and 29 men. We have 45 judges now, one post is vacant. But one should not forget that in 2023, the court elected its first woman president, Judge Shifra O'Leary. So we're getting there, slowly but surely.
Thank you. We are receiving quite a lot of questions about the modalities of lodging a case before the court. So I'm going to select 3. The first one concerns a so-called lack of detailed reasons which are given in single judge decisions. What do you say to applicants who wish for more detailed reasoning?
There are several judicial bodies within the court, and the competent judicial formation for examining manifestly inadmissible applications is a single judge. And let me say that out of around 38,000 cases decided by the Court last year, in 2025, around 27,500 cases were decided by a single judge. It shows how important is this proceeding for the court. The national judge, I mean the judge elected in respect of our country, is never the single judge as regards the respondent state. Previously, I used to be the single judge for Ukraine. And let me share with you my own experience. The decision taken by a single judge, which is the rejection of an application as inadmissible, is based on a huge work prepared by registry member staff. And this is for the judge to check, to decide whether or not he or she follows the proposal. And it's always possible for the single judge to refer the case to a collegial body. If not, the decision is taken and a letter is sent to the applicant. This proceeding was introduced in 2010 at a time when the backlog pending before the court was huge, so huge that for reasons of efficiency it was needed to find a new way to address this category of cases. But in 2015, the member states invited the court to provide more reasons. And this is needed for transparency. And we have to strike a fair balance between two different necessities. Efficiency on the one hand, transparency on the other hand. Let me say that. The letter sent to the applicants provides some reasons. Standardized reasons. Global formula, when no more is needed. But in some cases, reference to the existing case law and more detailed reasons are given to the applicants. It's important to imagine that if we do more at that level of manifestly inadmissible cases, could you imagine how demanding it would be for the court as regards judicial resources which have to be allocated to cases which deserve time, adversarial proceeding, and more detailed reasoning. So it's somehow a kind of compromise between these two needs, efficiency and transparency. We work a lot, but I want just once again to testify that nothing is decided by the court without a huge commitment of all those who work at the court, registry and judges.
Thank you very much. The second in this series of questions relates to the application form. Registrar, we've had a question asking, is the court moving to an electronic registration form?
Yes, thank you. This is a top priority for us, develop an online application form. We had this project before the pandemic, but we had to put it aside because we had to deal with other urgent matters to allow the court to work remotely. Now we have resumed our work on that project, and we are currently developing a prototype which we will test internally at the court at the second half of this year. And then we will call for bar associations and NGOs to make a full-scale external test. We plan to launch the first version of the online application form in 2027. The first version will resemble the paper version, so to allow the applicants and their lawyers to have a smooth transition from paper to electronics, and then we will see how we move forward. We will introduce also some artificial intelligence elements that will enable the court to translate documents, transliterate names, and also the applicants to make sure that they have accurately completed the online application form.
Thank you. This leads me to a third question in the series, which is related to the formal requirements under Rule 47. And one question asks, will these still remain as strict?
Well, these requirements are there to enable the court to properly examine applications submitted before it. The court was advised to do so when the reform process started back in 2010 with the Interlaken reform process. We were told that we need to be a little bit more strict with the criteria and the requirements we have in order for the court to be able to thoroughly and well examine all complaints brought before it. As I said just before, with the online application form, we will use artificial intelligence, which will also enable the applicants to properly tick all the good boxes. So they will not be able to submit the application form if all the requirements under Rule 47 are not properly met. So that's already a good point for the applicants. But even now, when some requirements under Rule 47 are not met, we give the possibility to applicants or their lawyers to correct that omission and submit what's missing from the file within a short deadline. So the only thing applicants and lawyers must really pay attention to is not to wait until the last moment to submit their application form, because by the time they will be given to correct the omission, probably the fourth month time limit will have expired.
Thank you very much. Je tourne maintenant au président Guyomar. On a reçu une question en français qui concerne la politique judiciaire. Président Guyomar, comment conciliez-vous dans votre rôle de président la défense de l'indépendance judiciaire avec une pédagogie active auprès des opinions publiques et des responsables politiques?
Merci pour cette question. Ça me permet de rappeler qu'il y a deux langues officielles à la Cour, l'anglais et le français, et que c'est une richesse de travailler dans les deux langues. L'indépendance judiciaire dont vous parlez, c'est le principe cardinal de l'état de droit. Et comme président de la Cour, je serai l'infatigable garant de cette indépendance. Mais l'indépendance judiciaire ne saurait suffire à elle seule. Elle doit avoir contrepartie une légitimité toujours réaffirmée de la juridiction. Et j'ai fixé comme priorité, lorsque j'ai pris des fonctions de président en mai dernier, pour mon mandat, les trois axes suivants, qui sont autant de fondements pour la légitimité de la Cour. Efficacité, visibilité et responsabilité. L'efficacité, nous venons d'en parler à plusieurs titres. C'est la bonne administration de la justice. Nous avons fait beaucoup de réformes, nous allons encore en faire pour progresser. Mais je veux dire que l'année dernière, à la fin de l'année dernière, comme notre rapport annuel l'a marqué, nous avons atteint le stock historiquement le plus bas depuis 20 ans. 53 000 affaires pendantes, là où il y a environ 15 ans, il y en avait 160 000. Mais l'efficacité ne sert pas si elle ne s'accompagne pas d'une visibilité. Il faut bien juger, qualité des jugements, juger dans un délai raisonnable, juger avec une bonne politique de priorisation, mais il faut donner à voir ce que nous faisons. Et c'est un élément très important de visibilité. Pour cela, nous devons réussir à parler en même temps à plusieurs cercles d'interlocuteurs différents. Ce que nous faisons aujourd'hui avec ce chat live, c'est que nous essayons de toucher le grand public. Et je remercie toutes celles et ceux qui nous écoutent ou qui nous posent des questions, parce que cela fait partie du rôle aujourd'hui de toutes les juridictions de se donner à voir et se donner à connaître pour être mieux compris. Alors, cela, évidemment, a un objectif, c'est d'obtenir l'adhésion des gens au système de l'état de droit et au rôle que la Cour européenne en particulier joue. Sans l'adhésion des gens dans une société démocratique, le système ne tiendra pas. Et c'est en cela aussi que nous rendons des comptes d'une certaine manière. C'est la responsabilité dont je parlais, accountability, on dirait en anglais, redevabilité en français. Les juridictions doivent expliquer très clairement ce qu'elles font, quelle est leur politique judiciaire, quel est leur rôle, ce qu'elles ont fait du mandat qu'elles ont reçu. Alors, pour cela, je crois qu'au lieu d'opposer indépendance, qui serait l'idée de rester à l'écart du monde, et engagement dans le monde, il faut combiner les deux en restant strictement indépendant, protégeant l'intégrité juridictionnelle de la Cour. Nous avons tout à gagner à aller au contact des personnes et à les embarquer dans une aventure collective pour leur redonner l'appétit pour les droits humains.
Merci beaucoup. Vous avez parlé de visibilité et effectivement, on a reçu une question concernant la politique de communication de la Cour. Madame la Greffière, pourriez-vous nous expliquer les innovations que la Cour a menées?
Oui, c'est une priorité pour nous, la communication. Comme le Président vient d'expliquer, il faut être visible, il faut expliquer c'est ce qu'on fait, mais aussi c'est ce qu'on ne fait pas. Parce que nous pensons que la confiance du public à la justice est liée à la transparence du processus judiciaire. Donc d'abord, c'est pour nous de diffuser notre jurisprudence, de rendre accessibles nos connaissances aux praticiens dans chaque État membre du Conseil de l'Europe. Et pour cela, je dois saluer la plateforme de connaissances, le Knowledge Sharing Platform, qu'on a externalisé en 2022 dans les 2 langues officielles du Conseil de l'Europe, l'anglais et le français, et qui permet maintenant à chaque avocat, juge, praticien, étudiant d'avoir une mine de connaissances et d'informations, les mêmes que nos juges et nos membres du greffe ont à leur disposition quand ils font leur travail. Qui plus est, cette plateforme de connaissances, on vient de la traduire en début de l'année dernière dans 3 langues non officielles, l'ukrainien, le roumain et le turc, et nous voulons bien la traduire, si nos finances le permettent, dans d'autres langues non officielles. Et pour nous, maintenant, la priorité, c'est l'allemand, parce que ça touche aussi un grand public. Et ensuite, on a vraiment innové. On fait par exemple maintenant des petites vidéos pour expliquer les affaires de grande chambre d'une façon simple et compréhensible. On fait des actions pédagogiques pour toucher les jeunes publics. Comme le Président vient de le dire, nous voulons toucher des gens qui sont en dehors des cercles de nos interlocuteurs habituels. Nous ouvrons aussi nos palais de justice en septembre dernier dans le cadre des célébrations pour le 75e anniversaire de la Convention. Nous avons tenu des portes ouvertes qui ont eu un net succès. On a accueilli plus de 4000 personnes de tout milieu dans notre bâtiment avec des actions pédagogiques. Nous avons parlé des travaux préparatoires, nous avons expliqué le travail de la Cour, le travail des juges, le travail du greffe. Et nous continuons. Nous avons aussi maintenant une présence accrue dans les réseaux sociaux. Nous sommes maintenant sur LinkedIn, la Cour a son compte, le Président a le sien, je le mien. On essaye de toucher le plus grand nombre de gens pour démystifier un peu, c'est ce qu'on fait.
Thank you very much.
Oui, si je peux juste ajouter quelque chose à ce que Madame la Greffière vient de dire. C'est très important de réussir, et toutes les juridictions aujourd'hui sont confrontées au même défi, à rester dans le champ judiciaire, parce que nous ne pouvons pas sortir de ce rôle-là. C'est notre mission, et nous devons rester intégralement dans le champ judiciaire, et sortir du palais, sortir de nos habitudes, pour aller toucher les gens par une communication qui soit pertinente, c'est-à-dire qui touche à l'objet de ce que nous faisons, mais qui touche au cœur des gens aussi. Et je voudrais dire, c'est très important que tout le monde comprenne que nos jugements sont faits avec des raisonnements juridiques, avec une logique qui est la garantie de la bonne justice. Mais nous devons aussi faire comprendre aux gens que la justice est humaine, faite par des personnes humaines, pour des personnes humaines, et que cette dimension du cœur est essentielle. C'est ça qu'il faut réussir à faire partager.
Thank you very much. I'd like to move on to another topic because we're receiving a lot of questions regarding the stock of Turkish cases. And I'm sorry that we won't have time to answer, you won't have time to answer all of these questions. But perhaps I could summarize to say that a lot of the questions we've received relate to the length of time that the court is taking to process these Turkish cases. And I'd like to ask you, President Guyomar, is justice delayed, justice denied?
Yes, justice delayed is justice denied. This is absolutely true. And the court has to decide in a reasonable time, within a reasonable time. This is absolutely important to recall it. We made some improvement as regards the length of proceeding, and we will pursue our efforts to improve more. But let me say something about the statistics. Since 2016, the court has received approximately 130,000 cases against Turkey alone. And as regards our docket, out of the 53,000 pending cases, around 28,000 are against Turkey. This is a huge challenge for the court to manage, to decide all these cases at this quantitative level. Second point, political, social time frame are not the same as judicial time frame. We have to decide cases in due time, but never in a hurry. Justice requires a certain time. Adversarial proceedings, full examination of the admissibility and the merits of each case, deliberations, reasoning, delivery. It takes a lot of time. And if the court wants to just play its role with the needed quality and full respect for both parties, it requires a certain time. And let me say also that for urgent matters, there is Rule 39 proceeding, which allows the court on the spot to indicate, if needed to prevent an irreparable harm, to indicate interim measure. This is complementary. As regards the Turkish cases, I would like just to add another thing. The prioritization of the cases is the most appropriate answer to be given to this challenge. And this is for the court to identify the impact cases which raise systemic issues as leading case or impact case, to decide them, and then it will be more, it will be easier just to decide massive or repetitive cases in line with this leading case. And this is what is done, not only as regards Turkish cases, but notably to tackle with this so important docket of cases versus Turkey.
And if I may, just to follow up from this, we've received another question about a possible influx of applications from Turkey concerning dismissal of civil servants, members of the judiciary, military officials and other officials. People are asking, what special measures has the court put in place to deal with these?
Indeed, the court is currently confronted with a significant influx of cases coming from Turkey. And since mid-October, last October 2025, the European Court has received more than 7,000 cases concerning the dismissal of civil servants in Turkey, or military officials, or members of the judiciary. And the court and the registry, I want just to express my sincere gratitude for the commitment of the more than 700 member staff of the registry, for the commitment to the court and the efficiency of the judiciary. With the registry, it has been decided just to innovate just a bit, to be capable of well addressing this unprecedented influx of cases. Applications submitted to the court must be accompanied in that matter by a cover page available at the court site. And this cover page is an essential administrative document that will facilitate the identification, registration, and proper handling of applications. It's important just to have a clear idea of what it means. All fields in the cover page are filed in electronically, and that once completed, the cover page will be printed. And a new QR code has been just put in place to facilitate both from the applicant side and both from the court side, the registration and the adjudication of this massive flux of Turkish cases.
Thank you.
It's what I call efficiency. And this is absolutely important just to remain agile, to accommodate what occurs in the current situation. And the court is agile.
I'd like to move now to some cases that we're receiving about Russia, Madam Registrar. Can you explain how the court is dealing with the pending cases against Russia?
Yes, thank you. Let me explain. Russian Federation was expelled from the Council of Europe in March 2022, and a few days later the plenary court met to decide on the consequences of the cessation of membership of the Russian Federation from the Council of Europe. And interpreting the convention, it decided the following. It decided that Russia would continue to be a high contracting party to the convention until 16 September 2022, for 6 more months, that is to say. It also decided that it would continue to deal with applications pending against the Russian Federation for alleged acts or omissions that may constitute violations of the convention that have occurred until that date, until the 16th September of 2022. This is what we call residual jurisdiction. So then we had to face, to find a good balance between the realities. At the time we had almost 17,000 individual cases pending against Russia and almost 6,000 conflict-related cases. So we had to find a balance between the figures we had and the means we had to deal with these cases. We grouped the cases in 3 categories. The first were the cases that required full judgment, cases very important for the international accountability of the Russian Federation under the convention system. And there we gave full judgment, and we have almost finished with these cases. Then were the cases that were a little bit more repetitive, which we dealt with more expedite procedure, and we have also finished these cases as well. So what remains are the conflict-related cases. But I need to stress once again that currently the European Court of Human Rights, it's the only international jurisdiction that holds Russia accountable for the alleged violations under the convention system.
Could I just ask another question there that we've just received? What is the point of the court processing these cases against Russia if Russia is not engaging with the court or the Council of Europe?
President?
Let me say again what you just, Madam Registrar, said. It is so important to keep in mind that for the time being, the court, the European Court of Human Rights, is the only international jurisdiction before which, in the international legal order, Russia is held responsible. And this is accountability for Russia. This is so important. And the role played by the court within the Council of Europe is fully complementary with other bodies. And I just want to mention the registry of damages. There are complementary roles. And it will be the same with some other structures or institutions which are planned. Let me add something about one of the most important judgments decided by the court since its creation. I mean the interstate grand chamber case delivered last July, on the 9th of July 2025. In the Netherlands and Ukraine versus Russia grand chamber case, which concerns the conflict in eastern Ukraine since 2014, and even since the beginning of military operation in February 2022. And I want just to flag one specific question at stake in this case, which which are the abductions of children, 3 groups of Ukrainian children from Ukraine to Russia. But the case concerns also the downing of flight MH17. That's why there were two interstate cases, Netherlands and Ukraine versus Russia. In this consumer case, the court found many systemic violations of the convention. And thus, the court affirmed, in the name of the European public order, that the convention system cannot tolerate the erasure of a member state's legal identity under the pressure of force on individual freedoms, on political liberties. By doing so, the court did not simply apply the law. The court documented the fact and provided history with a record bearing a legal seal. Indeed, this matters for the victims and for the principles of international law. The court's judgment is a historical record, a bill of accountability, a message to future generations. This is important, and by doing so, the court shows how important is the convention system for all people, all member states, notably in troubled times when the war is coming back.
Thank you very much. It just reminds me, we've received a question in French, and it relates to something that you've referred to, which is the convention is for all. A question, and I'll read it out here on the screen. Seriez-vous favorable à l'emploi de l'expression droits humains plutôt que droits de l'homme dans les arrêts de la Cour?
Il y a une politique très claire au Conseil de l'Europe que j'applique personnellement, et comme président de la Cour, je l'applique aussi. Lorsque les textes se réfèrent à l'expression droits de l'homme, c'est le cas de la Convention de 1950, dont nous avons fêté les 75 ans l'année dernière, dans sa version française, Convention de sauvegarde des droits de l'homme et des libertés fondamentales, nous utilisons les termes droits de l'homme. Pour le reste, nous utilisons en français l'expression droits humains, qui est la traduction directe de human rights. Il y a un grand débat en français. Et je suis très attaché à la langue. Je rappelle toujours que le droit est un acte de langage. C'est une grammaire sociale qui repose sur le maniement d'un acte de langage. Il y a un grand débat de savoir si droits humains ne seraient pas plus inclusifs que droits de l'homme. Parce que droits de l'homme laisserait de côté une partie, la partie féminine de la famille humaine. C'est vrai qu'à l'époque où on a utilisé ce terme, homme avait un sens générique. Et donc, concernait toutes les personnes humaines. Aujourd'hui, ça peut sembler ou être compris différemment. Je crois que droits humains est effectivement plus inclusif. À ce titre, mais à un autre égard que je voudrais partager avec vous. Dans l'expression droits humains, il y a un adjectif qualificatif, humain, qui rappelle que les droits ne sont pas la propriété de la personne humaine, mais une qualité inhérente à la personne humaine. Et à titre personnel, je suis très attaché à rappeler que les droits que nous nous reconnaissons mutuellement sont nos qualités et non notre propriété. Alors oui, à titre personnel, j'utilise toujours droits humains.
Merci beaucoup. Alors, je poursuis en français. On avait quelques questions concernant le traitement des affaires, Madame la Greffière, et une question. Comment la Cour sélectionne les affaires qu'il traite? Merci beaucoup.
Jusqu'à 2009, les affaires étaient examinées par ordre chronologique. Là, on s'est rendu compte que cela comportait les risques de voir attendre des affaires qui posaient des questions très urgentes pour la vie ou pour la santé des requérants. On a donc mis en place un système de priorisation avec 7 catégories. Les 3 premières sont les catégories les plus importantes, les plus urgentes, là où la vie, la santé, la liberté de la personne est en cause, ou des affaires qui posent des questions importantes, structurelles pour le système de la Convention. Nous avons opéré sur cette base jusqu'en 2021, où nous avons ajouté encore une catégorie des affaires prioritaires, les affaires dites à impact, c'est-à-dire des affaires qui sans être urgente au sens propre du terme, la vie de personne n'est en danger, personne n'est torturé, mais qui pose des vraies questions importantes, soit pour l'État concerné, soit pour l'ordre juridique européen en général. Donc ces affaires sont aussi examinées après les affaires urgentes, en priorité aussi, et nous avons identifié ces affaires et nous avons fixé des délais dans lesquels ces affaires doivent être traitées. Nous avons passé de 64 mois de leur traitement à 28 actuellement. On se rapproche de 18 mois qu'on va attendre pour le traitement de ce type d'affaires. Je peux vous donner un exemple des affaires qu'on a traitées l'année dernière. C'est une affaire contre la France concernant le devoir conjugal. La requérante qui voulait divorcer de son mari s'est vue imposer le divorce à cet ordre exclusif parce qu'elle avait renoncé à avoir des relations intimes avec son mari en violation du devoir conjugal. La Cour a jugé que le devoir conjugal va à l'encontre de la liberté sexuelle de la personne et à l'encontre du consentement qui peut être révocable à tout moment. Elle a donc trouvé une violation de l'article 8 de la Convention qui garantit le droit, qui protège le droit à la vie privée. Et dans la foulée, pour montrer à quel, pas seulement c'était une affaire à impact pour toutes les femmes concernées, mais aussi pour l'État, parce que dans la foulée, très vite, sans trop tarder, le Parlement français a aboli le devoir conjugal. Donc ça n'existe plus dans la loi. Ça montre aussi l'influence qu'a la Cour dans les juridictions nationales.
Oui, si je peux me permettre d'ajouter à cet exemple un mot, je crois qu'il est emblématique de ce que nous appelons la responsabilité partagée. Le système de la Convention repose sur ce partage des rôles. La Cour intervient à son tour et à sa place. À son tour, après l'épuisement des voies de recours internes, ça veut dire que les juges nationaux doivent d'abord être saisis par les gens qui s'estiment victimes, et à sa place, dans le respect du principe de subsidiarité, en laissant une certaine marge d'appréciation aux États. Mais cette responsabilité partagée donne beaucoup de pouvoir aux autorités nationales. Et en amont, ce sont eux qui prennent la loi, l'appliquent et la jugent. Et en aval. Et cet exemple donné par Mme la Greffière montre à quel point l'impact de nos décisions dépend aussi de la réactivité et de la réponse donnée par les États au jugement de la Cour. L'exécution des arrêts dépend du comité des ministres. Mais je voudrais dire que plus de 80% de nos arrêts, qui sont obligatoires, sont exécutés. Ça veut dire que les États jouent le jeu du système conventionnel. Sans eux, ça ne marcherait pas. Et c'est tous ensemble que nous permettons à cette convention d'être une protection effective pour chacune et chacun.
Merci pour cette réponse parce qu'effectivement, on a eu des questions sur la subsidiarité. Et sur l'exécution des arrêts, je vais toucher un mot un peu à la fin. Because first I'd like to ask, we've had quite a few questions about sensitive political discussions that are ongoing now in the Council of Europe that touch question of migration and the court's case law. So one question asks, does the court prevent national authorities from controlling their borders? Another question, what do you say about recent legislative initiatives in respect of migration in, for example, Denmark?
Let me start by sharing some statistics to address this question. Only about 1.5% of pending applications before the court relate directly or indirectly to migration matters or asylum matters. Since 2016, the court has decided more than 430,000 cases. 430,000 cases. And fewer than 300 judgments have found a violation of one or several rights secured by the Convention in cases connected to migration-related issues. That being said, it's not in my place. It's not my place as President of the Court to comment political initiative or a political process which are fully in the sovereign hands of member states. And I recall that there is an ongoing process before the Council of Europe until the summit planned next May in Chisinau, which is supposed to land up with a declaration adopted by the member states. And it's important for the court not to interfere with this political process. Like all courts, the European Court must remain strictly within the judicial sphere. But I would like also to point out that there is no question to ask to the court to engage in politics. As I said to British journalists, we hear what you say, but don't tell us what to do. The integrity of the judicial mission presupposes the absence of any political pressure exerted on the court or its judges. This is crucial. And this is what means separation of powers, which is the crux of the rule of law.
Thank you. I have two last questions. So one that we have received is on the Convention as a living instrument, and that's something that interests a lot of the people who've written into us. And how will the court interpret the Convention in response to new challenges? So we've had a few questions, for example, on how the court will respond to artificial intelligence, climate change, bioethics. Perhaps you could answer that.
In 1950, the court was deliberately drafted in general and inclusive terms. It was the choice made by the founders of the system, precisely to allow the court and its judges to adapt the scope of its rights to new circumstances. This is what means living instrument. This is the expression of judicial pragmatism, which means to interpret a text, the Convention, within a given context. And this is absolutely needed for the effectiveness of the protection provided to the people. It is needed so that it speaks to realities that were unforeseeable at the material time, including issues related to new technologies, artificial intelligence or climate change. But it is important to keep in mind that this living instrument, which refers to the doctrine of living tree, we have just to adapt the Convention to the current situation, has strict limits. It's not for the court to play the role of Parliament. It's not for the court to create new rights, but it is for the court, through its interpretation of the Convention, to address unprecedented issues. Let me say something about the climate change. In 2024, in Grand Chamber cases, the court adopted a very important ruling as regards the positive obligations for the state to tackle with this climate change, and for the first time decided that it is important to take on board the interest of future generations. This is also what means a court for all, including future generations.
Thank you. So, a last question. You mentioned before, President Guyomar, the implementation of the court's judgments. And we've had a couple of questions come in on what can the court do to make sure that the states are implementing the court's judgments and they are really effective.
This is the framework of shared responsibility. By signing the Convention, the states took some engagement to secure the rights vis-à-vis all persons under their jurisdiction. This is for the court, by adjudicating cases, in this case-by-case approach, to decide whether or not some breaches of the Convention rights are fund? If so, this is for the states, within the Committee of Ministers, through monitoring proceeding, to concretely, effectively implement the mandatory judgment of the court. The court has no specific role to play at that stage. But what is important, and this is also what implies judicial pragmatism, is to keep in mind this realistic approach and to be capable at the same time to fully protect the individual rights secured by the Convention and to provide some guidelines, some guidance to the respondent state in order to facilitate the concrete implementation of the judgment. There are complementary roles.
Thank you very much. So now I think we've come to the end of the time that has been allotted to us. Would you like to say any last concluding words, Registrar?
Well, this was a first attempt we had to do this live YouTube. I hope you've enjoyed it. It's a novelty for us. It's part of our efforts to enhance our outreach, and maybe you'll see us again or not. However, our communication policy is, as I said, one of our top priorities, and we are very much committed in getting closer and reaching as many audiences as possible. So I would really like to thank you for joining us today, and I hope you have enjoyed it. Thank you so much.
President Guyomar.
Je vais parler en français et en anglais. D'abord pour dire merci à toutes celles et ceux qui ont participé à ce chat live. Comme Madame la Greffière Tsirli l'a dit, c'était un exercice inédit. J'espère qu'il a comblé vos attentes. En tout cas, nous sommes très engagés à continuer à essayer de venir expliquer, clarifier, partager avec vous ce que fait la Cour cas après cas, jour après jour. Et ce que je voudrais dire, c'est que c'est important parce que nous avons la Convention en partage. Human rights are in our hands. The court is not alone to make the system sustainable. This is for all people, day after day, in the daily life, to commit themselves in order that, at the end of the day, our shared values, our ideals of peace and justice will prevail. We remain confident. We rely on you. You can rely on the court. Thank you.
Thank you very much. And goodbye.
Merci beaucoup. Au revoir.
Merci.